Question 1. Comparative studies suggest that applicants for a possession and acquisition license, PAL, in Ontario, Canada, often face challenges in accurately presenting their personal history. Considering the regulatory framework governing firearms licensing in Ontario, which of the following approaches best reflects the professional and legal obligations of an applicant when disclosing a history of mental health treatment? Option A. Provide only generalized statements about having sought mental health support without detailing the specific condition, treatment, or outcome. Option B. Assume that any past mental health diagnosis, regardless of resolution or treatment, automatically disqualifies an applicant and therefore refrain from disclosing it. Option C. Minimize or omit details about past mental health diagnoses and treatment, particularly if the applicant believes it could lead to an automatic denial. Option D. Proactively and comprehensively disclose the specific mental health diagnosis, the duration and nature of treatment received, prescribed medications, and evidence of successful recovery and stability. Correct answer is D. Proactively and comprehensively disclose the specific mental health diagnosis, the duration and nature of treatment received, prescribed medications, and evidence of successful recovery and stability. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to accurately assess and disclose their mental health history in a way that is both truthful and demonstrates they can safely possess and acquire firearms. The challenge lies in balancing the legal requirement for disclosure with the potential for stigma or misinterpretation of mental health conditions, while ensuring public safety remains paramount. Careful judgment is required to present information clearly and comprehensively, without omitting relevant details or exaggerating the impact of a condition. Correct approach analysis. The best professional practice involves the applicant proactively and comprehensively disclosing their mental health history, including the specific diagnosis, the duration of treatment, the prescribed medications, and the outcome of the treatment. This approach is correct because it aligns with the fundamental principle of the Firearms Act, Canada, and its associated regulations, which mandate full and honest disclosure to enable the Chief Firearms Officer, CFO, to make an informed risk assessment. By providing detailed information, the applicant demonstrates transparency and allows the CFO to evaluate their fitness to possess a firearm based on objective evidence of recovery and stability, rather than assumptions or incomplete information. This proactive disclosure is ethically sound, as it prioritizes public safety by ensuring the licensing authority has all necessary information. Incorrect approaches analysis. One incorrect approach involves minimizing or omitting details about a past mental health diagnosis and treatment, especially if the applicant believes it might negatively impact their application. This is professionally unacceptable because it constitutes a failure to provide complete and truthful information as required by law. Such omissions can lead to the denial of a PAL or the revocation of an existing one if discovered later, and can undermine public trust in the firearms licensing system. Another incorrect approach is to provide vague or generalized information about mental health without specific details regarding diagnosis, treatment, or prognosis. This is professionally unacceptable, as it hinders the CFO's ability to conduct a proper risk assessment. The legislation requires sufficient detail to assess the applicant's current fitness and the likelihood of future risk, which vague statements cannot provide. A third incorrect approach is to assume that a past diagnosis, even if resolved, automatically disqualifies an applicant, and therefore to not disclose it at all. This is professionally unacceptable because it is based on an incorrect assumption about the law and the assessment process. The Firearms Act, Canada, focuses on current fitness and risk, not solely on past diagnoses. By not disclosing, the applicant fails to provide the CFO with the opportunity to assess their current suitability based on all relevant information, including evidence of successful treatment and recovery. Professional reasoning. Professionals involved in the firearms licensing process, including applicants and those advising them, should adopt a decision-making framework that prioritizes transparency, accuracy, and adherence to the spirit and letter of the law. This involves understanding that the goal of the risk assessment is to ensure public safety, while allowing eligible individuals to obtain a PAL. Applicants should be encouraged to provide all relevant information truthfully and comprehensively, seeking clarification from the CFO or legal counsel if unsure about disclosure requirements. The process should be viewed as an opportunity to demonstrate fitness, not as an adversarial hurdle. Question 2. The investigation demonstrates that an applicant for a possession and acquisition license, PAL, in Ontario has a documented history of domestic disputes. Considering the paramount importance of public safety in firearms licensing, what is the most appropriate course of action for the licensing authority? Option A. Approve the PAL application without further investigation, assuming the disputes are minor and do not pose a current risk. Option B. Automatically deny the PAL application due to the presence of any documented domestic disputes, regardless of the specific circumstances. Option C. Conduct a thorough risk assessment, examining the nature, recency, and severity of the domestic disputes to determine if they indicate a propensity for violence or a disregard for the law, in accordance with the Firearms Act, Canada. Option D. Rely on informal reports and community gossip regarding the domestic disputes to inform the licensing decision. Correct answer is C. Conduct a thorough risk assessment, examining the nature, recency, and severity of the domestic disputes to determine if they indicate a propensity for violence or a disregard for the law, in accordance with the Firearms Act, Canada. Explanation. The investigation demonstrates a scenario where an applicant for a possession and acquisition license, PAL, in Ontario has a history of domestic disputes. This situation is professionally challenging because it requires balancing the applicant's right to apply for a license with the paramount public safety concerns inherent in firearms ownership. Careful judgment is required to assess the risk posed by the applicant's past behavior without unfairly prejudicing them, while strictly adhering to the requirements of the Firearms Act, Canada, and its associated regulations, as administered by the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program. The best professional approach involves a thorough risk assessment that prioritizes public safety and compliance with the Firearms Act. This entails a comprehensive review of the applicant's history, including any documented instances of domestic disputes, and evaluating the nature, severity, and recency of these incidents. The assessment must consider whether these incidents indicate a propensity for violence or a disregard for the law, which are critical factors in determining an applicant's suitability to possess firearms. This approach aligns with the legislative intent to prevent firearms from falling into the hands of individuals who may pose a risk to themselves or others, as mandated by Sections 5 and 6 of the Firearms Act, which outline the eligibility criteria and the prohibition against issuing licenses to individuals deemed a public safety concern. An incorrect approach would be to automatically deny the license based solely on the mention of domestic disputes, without a detailed assessment of the circumstances. This fails to acknowledge that not all disputes equate to a risk to public safety and could lead to an unfair denial. Another incorrect approach would be to approve the license without any further investigation into the domestic disputes, effectively ignoring potential red flags and contravening the duty to ensure public safety. Furthermore, relying on anecdotal information or hearsay without verifiable documentation or official reports would also be professionally unacceptable, as it lacks the objective basis required for such a significant decision. Professionals in this field should employ a structured decision-making framework that begins with a clear understanding of the legal requirements for PAL eligibility. This framework should include gathering all relevant information, conducting a balanced risk assessment that considers both the applicant's circumstances and public safety, and making a decision that is supported by evidence and consistent with the Firearms Act and its regulations. The process must be fair, transparent, and focused on preventing harm. Question 3. Analysis of a situation in Ontario, Canada, where an applicant for a possession and acquisition license, PAL, has a documented history of a serious altercation with a neighbor 2 years prior. While no charges were laid, the incident involved threats and was reported to the police. The applicant has otherwise maintained a clean record. What is the most appropriate course of action for the Registrar of Firearms when assessing this applicant's eligibility under the Canadian Firearms Act? Option A. Request a psychological evaluation of the applicant based solely on the reported altercation, without considering other aspects of their background or the nature of the incident. Option B. Conduct a thorough review of the documented altercation, including police reports and witness statements if available, to assess its relevance to the applicant's current fitness to possess a firearm, and consider this information alongside other eligibility criteria. Option C. Immediately approve the PAL application, as the applicant has no criminal convictions and the past incident did not result in charges. Option D. Deny the PAL application solely based on the reported altercation, regardless of the absence of criminal charges, citing potential public safety concerns. The correct answer is B. Conduct a thorough review of the documented altercation, including police reports and witness statements if available, to assess its relevance to the applicant's current fitness to possess a firearm, and consider this information alongside other eligibility criteria. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the complexities of the Canadian Firearms Act and its associated regulations concerning the acquisition of firearms. The applicant's past behavior, even if not resulting in a criminal conviction, raises concerns about their suitability and potential risk. A careful assessment is needed to balance the applicant's rights with public safety, adhering strictly to the legal framework. Correct approach analysis. The best professional practice involves a thorough review of the applicant's entire history as required by the Firearms Act and its regulations, specifically focusing on any information that might indicate a risk to public safety. This includes scrutinizing the details of the past incident, even if it did not lead to a conviction, and considering how it might relate to the applicant's current fitness to possess a firearm. The Firearms Act and the Criminal Code of Canada provide the framework for assessing an applicant's eligibility, which includes considerations beyond formal convictions. The Registrar of Firearms has a duty to ensure that only suitable individuals are granted a possession and acquisition license, PAL. Therefore, a comprehensive and diligent investigation into all relevant information is mandated. Incorrect approaches analysis. One incorrect approach would be to dismiss the past incident solely because it did not result in a criminal conviction. This fails to acknowledge the registrar's discretion and the broader mandate to assess public safety. The law does not limit the assessment to only formal convictions. Past behavior can be indicative of future risk. Another incorrect approach would be to grant the PAL without further inquiry, assuming the absence of a conviction means the applicant is automatically eligible. This neglects the due diligence required by the registrar and could potentially put the public at risk, violating the spirit and intent of firearms legislation. A third incorrect approach would be to deny the PAL solely based on the past incident without a thorough and documented assessment of its relevance to the applicant's current fitness. While public safety is paramount, the decision must be based on a fair and comprehensive review of all available information and legal criteria. Professional reasoning. Professionals in this field must adopt a risk-based assessment framework. This involves understanding the specific legislative requirements, such as those found in the Canadian Firearms Act and its regulations. They must gather all relevant information, assess its potential impact on public safety, and make a decision that is both legally sound and ethically responsible. This requires a commitment to due diligence, impartiality, and a thorough understanding of the legal criteria for licensing. Question 4. Consider a scenario where an individual in Ontario is applying for a possession and acquisition license PAL and has a history of a domestic dispute that resulted in a temporary peace bond, but no criminal charges were laid. Which approach best demonstrates responsible risk assessment and compliance with the Canadian Firearms Program's requirements? Option A. The applicant decides not to mention the peace bond, believing that since it did not result in a criminal conviction, it is not a factor the Canadian Firearms Program would consider. Option B. The applicant asks a family member who was aware of the domestic dispute to contact the Canadian Firearms Program on their behalf to explain the situation. Option C. The applicant only discloses information explicitly requested on the PAL application form, assuming the peace bond is irrelevant as no criminal charges were filed. Option D. The applicant proactively discloses the existence of the peace bond and explains the circumstances to the Canadian Firearms Program, providing any supporting documentation available. Correct answer is D. The applicant proactively discloses the existence of the peace bond and explains the circumstances to the Canadian Firearms Program, providing any supporting documentation available. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the complexities of the Canadian Firearms Act and its associated regulations concerning the acquisition of firearms, specifically handguns, while also demonstrating a clear understanding of the risk assessment process mandated by the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program, CFP. The applicant must not only meet the basic eligibility criteria, but also satisfy the CFP that their acquisition poses no undue risk to public safety. This involves a proactive and transparent approach to disclosing relevant information. Correct approach analysis. The best professional practice involves the applicant proactively and comprehensively disclosing all relevant information to the CFP during the application process, including any past incidents that might be perceived as a risk, even if not explicitly criminal. This approach aligns with the spirit and intent of the Firearms Act, which prioritizes public safety. By providing full disclosure, the applicant demonstrates honesty and a commitment to meeting the CFP's risk assessment requirements, allowing the program to make an informed decision. This transparency is crucial for building trust and ensuring compliance with the regulatory framework governing firearms possession and acquisition in Canada. Incorrect approaches analysis. One incorrect approach involves the applicant only disclosing information that is explicitly requested or that they believe is legally mandated to be disclosed. This approach is flawed because it relies on a narrow interpretation of disclosure requirements and fails to acknowledge the CFP's broad mandate for risk assessment. The CFP is empowered to consider any information that may indicate a risk to public safety, and withholding potentially relevant information, even if not directly asked for, can be interpreted as a lack of candor and may lead to the denial of the PAL. Another incorrect approach is for the applicant to assume that past incidents that did not result in a criminal conviction are irrelevant and therefore do not need to be disclosed. This is a significant misjudgment. The CFP's risk assessment is not solely based on criminal convictions. Past behaviors, incidents, or associations that suggest a propensity for violence, irresponsibility, or a disregard for safety can be considered. Failing to disclose such incidents, even if they did not lead to formal charges, can be seen as an attempt to conceal information that might influence the CFP's decision, thereby undermining the integrity of the application process. A further incorrect approach is for the applicant to rely on a friend or family member to inform the CFP about any potential concerns, rather than disclosing it themselves. While well-intentioned, this shifts the responsibility for disclosure away from the applicant. The application for a possession and acquisition license is a personal undertaking, and the onus is on the applicant to be truthful and complete in their submissions. Delegating this responsibility is not an acceptable practice and does not demonstrate the applicant's personal commitment to fulfilling their obligations under the Firearms Act. Professional reasoning. Professionals should adopt a proactive and transparent approach to firearms licensing applications. This involves thoroughly understanding the requirements of the Canadian Firearms Act and the CFP's risk assessment criteria. When in doubt about the relevance of any past incident or personal circumstance, it is always best to err on the side of disclosure. Seeking advice from qualified legal counsel specializing in firearms law can also be beneficial in understanding disclosure obligations and navigating complex situations. The overarching principle should always be to demonstrate a clear commitment to public safety and to foster trust with the regulatory authorities. Question 5. During the evaluation of a possession and acquisition license, PAL, application in Ontario, an applicant has a past conviction for assault that occurred over a decade ago, a period of mental health challenges that were resolved with treatment, and a past domestic dispute that involved police intervention but no charges were laid. What is the most appropriate approach for the applicant to take regarding the disclosure of these past incidents on their PAL application? Option A. Provide a vague and generalized description of the mental health challenges, focusing on the fact that they are resolved, without detailing the specific circumstances or treatment received. Option B. Omit the past conviction for assault, as it occurred a significant time ago, and the applicant believes it is no longer relevant to their current suitability to possess firearms. Option C. Downplay the domestic dispute by describing it as a minor disagreement, as no charges were laid, and it was not a significant event in the applicant's life. Option D. Fully and truthfully disclose all past incidents, providing complete details of the conviction, the nature of the mental health challenges and treatment, and the circumstances of the domestic dispute, allowing the Registrar of Firearms in Ontario to make an informed assessment. The correct answer is D. Fully and truthfully disclose all past incidents, providing complete details of the conviction, the nature of the mental health challenges and treatment, and the circumstances of the domestic dispute, allowing the Registrar of Firearms in Ontario to make an informed assessment. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the applicant to disclose potentially sensitive personal information that could impact their eligibility for a possession and acquisition license, PAL, in Ontario. The challenge lies in accurately and truthfully representing past incidents without misrepresenting or omitting crucial details, as any misrepresentation can have severe consequences under the Firearms Act, Ontario. Careful judgment is required to determine what constitutes a relevant disclosure and how to present it effectively. Correct approach analysis. The best professional practice involves a thorough and honest disclosure of all relevant past incidents to the Registrar of Firearms in Ontario. This approach directly aligns with the requirements of the Firearms Act, Ontario, and its associated regulations, which mandate full disclosure of any information that might be relevant to the applicant's suitability to possess firearms. By proactively and truthfully providing all requested information, the applicant demonstrates good character and adherence to the law, which is a cornerstone of the PAL application process. This approach minimizes the risk of future complications and upholds the integrity of the firearms regulatory system in Ontario. Incorrect approach is analysis. Failing to disclose a past conviction for assault, even if it occurred many years ago and the applicant believes it is irrelevant, is a significant regulatory failure. The Firearms Act, Ontario, requires disclosure of all convictions, and the registrar will assess their relevance. Omitting this information constitutes a misrepresentation, which can lead to the immediate refusal of the PAL application and potential future prohibitions. Providing a vague and incomplete description of a past mental health crisis without detailing the circumstances or treatment received is also professionally unacceptable. While mental health is a sensitive topic, the application process requires sufficient information for the registrar to assess the applicant's current mental state and any potential risks. Vague disclosures can be interpreted as an attempt to conceal relevant information, leading to further scrutiny and potential denial. Minimizing the severity of a past domestic dispute by stating it was a minor disagreement when it resulted in police involvement, and a warning is a misrepresentation of facts. The Firearms Act, Ontario, considers incidents involving domestic disputes and police intervention as highly relevant to an applicant's suitability. Downplaying such an event undermines the applicant's credibility and demonstrates a lack of understanding of the seriousness with which such matters are treated under firearms legislation in Ontario. Professional reasoning. Professionals evaluating PAL applications in Ontario must adopt a framework of absolute transparency and honesty. This involves a meticulous review of all personal history, identifying any incidents that could be construed as relevant to firearm possession. The decision-making process should prioritize full disclosure, even for incidents that the applicant might deem minor or irrelevant, as the ultimate determination rests with the registrar. Professionals should guide applicants to provide comprehensive and truthful information, understanding that any attempt to conceal or misrepresent facts will likely result in severe penalties and a permanent negative impact on their ability to legally possess firearms in Ontario. Question 6. Research into the application process for a possession and acquisition license, PAL, in Ontario, Canada, has revealed that an applicant who has no criminal convictions is seeking to renew their license. During their youth, approximately 10 years ago, they were charged with a minor assault, which was subsequently dismissed by the court. The applicant believes this dismissed charge is irrelevant to their current application and is considering not mentioning it on the renewal form. What is the most appropriate course of action for this applicant regarding the dismissed assault charge? Option A. Disclose the dismissed assault charge only if the applicant believes it might be discovered through a background check. Option B. Assume that a dismissed charge is not a reportable event and therefore omit it from the renewal application. Option C. Fully disclose the dismissed assault charge on the PAL renewal application, providing any necessary details requested by the Chief Firearms Officer. Option D. Only disclose the dismissed assault charge if the application form specifically asks about charges that did not result in a conviction. The correct answer is C. Fully disclose the dismissed assault charge on the PAL renewal application, providing any necessary details requested by the Chief Firearms Officer. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the complexities of the Canadian Firearms Act and its associated regulations, specifically concerning the assessment of risk factors that could impact their eligibility for a possession and acquisition license, PAL. The challenge lies in accurately and comprehensively disclosing all relevant information, even if the applicant believes it is minor or resolved, to ensure a fair and lawful assessment by the Chief Firearms Officer, CFO. Failure to do so can lead to license refusal, revocation, and potential legal consequences. Correct approach analysis. The best professional practice involves a proactive and transparent approach to risk disclosure. This means the applicant should fully disclose all past incidents, including the minor assault charge, regardless of whether it was dismissed or expunged. The Firearms Act requires applicants to disclose any findings of guilt, charges, or circumstances that might indicate a risk to public safety. By fully disclosing the dismissed assault charge, the applicant demonstrates honesty and allows the CFO to conduct a thorough risk assessment based on complete information, adhering to the spirit and letter of the Firearms Act and the Criminal Records Act. This approach prioritizes public safety and regulatory compliance. Incorrect approaches analysis. One incorrect approach is to only disclose the dismissed assault charge if it resulted in a conviction or a conditional discharge. This is a regulatory failure because the Firearms Act requires disclosure of charges laid, not just convictions. A dismissed charge still represents an interaction with the justice system that the CFO is entitled to consider as part of a comprehensive risk assessment. Another incorrect approach is to assume that because the charge was dismissed, it is irrelevant and therefore not disclosable. This is an ethical and regulatory failure as it misinterprets the scope of disclosure requirements. The CFO's mandate is to assess risk to public safety, and any past behavior that could be construed as a risk, even if not leading to a conviction, is pertinent to this assessment. A further incorrect approach is to only disclose information that the applicant believes is significant. This is a flawed decision-making process because the determination of significance rests with the CFO, not the applicant. The applicant's subjective interpretation of relevance can lead to omissions that are critical from a regulatory perspective, potentially jeopardizing their application. Professional reasoning. Professionals in this situation should adopt a, when in doubt, disclose mentality. The decision-making process should involve thoroughly reviewing the requirements of the Firearms Act and the application form, understanding that the onus is on the applicant to provide all requested information. If there is any ambiguity about whether an event needs to be disclosed, it is always safer and more compliant to disclose it. This approach minimizes the risk of misrepresentation or omission, which are serious grounds for license refusal or revocation. Question 7. Governance review demonstrates that a PAL holder in Ontario, Canada, has recently moved into a shared residence with an individual who has a history of domestic disputes, though no criminal charges were laid. The PAL holder has not yet informed the Chief Firearms Officer, CFO, of Ontario of this change in living arrangements. Which of the following approaches best reflects responsible and compliant conduct in this situation? Option A. Proactively and truthfully disclose the change in living arrangements to the Chief Firearms Officer of Ontario as soon as reasonably possible. Option B. Only report the change in living arrangements if specifically asked by the CFO. Option C. Wait to see if the change in living situation is discovered by the CFO before reporting it. Option D. Assume the change is not relevant to the CFO, as the new roommate has no criminal record. Correct answer is A. Proactively and truthfully disclose the change in living arrangements to the Chief Firearms Officer of Ontario as soon as reasonably possible. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual to navigate the complexities of firearm ownership regulations in Ontario, Canada, while also managing personal circumstances that could impact their eligibility. The core challenge lies in balancing the legal requirements for maintaining a possession and acquisition license, PAL, with the need for transparency and timely reporting to the authorities. Failure to do so can have serious legal consequences, including license revocation and potential criminal charges. Careful judgment is required to ensure compliance and uphold public safety. Correct approach analysis. The best professional practice involves proactively and truthfully disclosing the change in living arrangements to the Chief Firearms Officer, CFO of Ontario, as soon as reasonably possible. This approach aligns with the fundamental principles of the Firearms Act, Canada, and the regulations governing PALs, which emphasize the applicant's or license holder's ongoing responsibility to inform the CFO of any material changes that could affect their eligibility. Specifically, the Criminal Records Act and provincial legislation in Ontario require individuals to be of good character and not pose a risk to public safety. Failing to report a change in residence, especially one involving a person with a history of domestic disputes, could be interpreted as a lack of candor or an attempt to circumvent scrutiny, thereby undermining the licensing system's integrity and public safety objectives. Prompt and honest communication demonstrates a commitment to responsible firearm ownership and adherence to legal obligations. Incorrect approach is analysis. One incorrect approach involves waiting to see if the change in living situation is discovered before reporting it. This is a serious regulatory failure as it constitutes a lack of transparency and potentially an attempt to conceal information that is material to the license holder's eligibility. The Firearms Act places a positive obligation on license holders to report such changes, and passive waiting is a breach of this duty. Ethically, it demonstrates a disregard for the trust placed in license holders and prioritizes personal convenience over public safety. Another incorrect approach is to only report the change if specifically asked by the CFO. This also represents a failure to meet the proactive reporting obligations mandated by the legislation. The onus is on the license holder to initiate the disclosure of relevant information, not to wait for an inquiry. This approach suggests a minimal compliance mindset rather than a genuine commitment to responsible firearm ownership and regulatory adherence. A third incorrect approach is to assume that since the new roommate does not have a criminal record, the change in living situation is not relevant. While the roommate's criminal record is a factor, the CFO's assessment of eligibility is broader and considers the overall environment and potential risks associated with the license holder's residence. The presence of domestic disputes, even without criminal charges, can be a relevant factor in assessing public safety. Failing to report the change based on this assumption is a misinterpretation of the CFO's mandate and the comprehensive nature of risk assessment in firearm licensing. Professional reasoning. Professionals in this situation should adopt a proactive and transparent approach. Decision-making frameworks should prioritize understanding and adhering to the specific reporting obligations under the Firearms Act, Canada, and Ontario provincial regulations. This involves recognizing that any change in living circumstances that could impact public safety or the license holder's eligibility must be reported to the CFO. When in doubt about the relevance of a change, it is always best to err on the side of caution and disclose the information. Maintaining open communication with the licensing authority is paramount to ensuring continued compliance and upholding the integrity of the firearm licensing system. Question 8. The audit findings indicate that a firearms safety course instructor in Ontario has been primarily focusing on the practical aspects of firearm handling during their courses, with minimal emphasis on the administrative requirements for obtaining a possession and acquisition license, PAL. When applicants inquire about the reference section of the PAL application, the instructor generally advises them to find people who know you well, without delving into the specific criteria for suitable references as outlined in Canadian federal law. Furthermore, the instructor has not been actively reviewing the completed application forms for completeness or accuracy before the applicants submit them to the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program. Which of the following approaches best reflects the professional responsibilities of a firearms safety course instructor in Ontario concerning the PAL application process? Option A. Overlook or downplay the importance of the applicant's declarations regarding criminal history or mental health, assuming that the RCMP will conduct its own comprehensive background checks and that the instructor's role is limited to safety training. Option B. Provide generalized advice about references, such as find people who know you well, and trust that the RCMP will conduct thorough background checks to verify all information. Option C. Primarily focus on the practical firearms handling skills during the course, assuming the administrative aspects of the application are the applicant's sole responsibility and will be handled by the authorities later. Option D. Meticulously review the applicant's completed application form, focusing on the sections pertaining to references and the declaration of any past criminal convictions or mental health issues that might impact eligibility, and ensure the applicant understands these requirements. The correct answer is D. Meticulously review the applicant's completed application form, focusing on the sections pertaining to references and the declaration of any past criminal convictions or mental health issues that might impact eligibility, and ensure the applicant understands these requirements. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the firearms safety course instructor to balance their duty to uphold the integrity of the licensing process with the need to provide clear and accurate instruction. Misinterpreting or misapplying the requirements of the Firearms Act, Canada, and its associated regulations can lead to individuals obtaining licenses they are not legally entitled to possess, thereby compromising public safety. The instructor must exercise careful judgment to ensure all applicants understand and meet the legal prerequisites for a possession and acquisition license, PAL. Correct approach analysis. The best professional practice involves the instructor meticulously reviewing the applicant's completed application form, specifically focusing on the sections pertaining to references and the declaration of any past criminal convictions or mental health issues that might impact eligibility. This approach is correct because it directly addresses the core requirements mandated by the Firearms Act, Canada, and the Firearms Safety Courses regulations. The Act requires applicants to demonstrate they are fit to possess firearms, which includes providing suitable references and truthfully disclosing any disqualifying factors. The instructor's role is to facilitate the applicant's understanding of these requirements and to ensure the application is complete and accurate before it proceeds to the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program for final assessment. This proactive review ensures the applicant is aware of their obligations and that the application is submitted with the highest degree of accuracy, minimizing the risk of rejection or future issues. Incorrect approaches analysis. One incorrect approach involves the instructor solely focusing on the practical firearms handling skills during the course, assuming the administrative aspects of the application are the applicant's sole responsibility and will be handled by the authorities later. This is professionally unacceptable because it abdicates the instructor's responsibility to ensure applicants understand the full scope of PAL requirements, including the critical eligibility criteria outlined in the Firearms Act. Instructor is an integral part of the initial screening process, and neglecting the application's integrity undermines the system. Another incorrect approach is for the instructor to provide generalized advice about references without verifying if the applicant has actually identified and contacted suitable individuals as per the regulations. This is professionally unacceptable, as it fails to ensure the applicant has met a specific regulatory requirement. The regulations stipulate the need for references who can attest to the applicant's suitability, and simply advising them to get references without confirmation is insufficient. A further incorrect approach is for the instructor to overlook or downplay the importance of the applicant's declarations regarding criminal history or mental health, assuming that the RCMP will conduct its own thorough background checks. This is professionally unacceptable because it bypasses a crucial step where the instructor can identify potential red flags early on and ensure the applicant understands the gravity of these declarations. While the RCMP conducts final checks, the instructor has a duty to ensure the application is presented truthfully and completely from the outset, as per the spirit and letter of the Firearms Act. Professional reasoning. Professionals in this role should adopt a comprehensive approach that integrates practical training with a thorough understanding and application of the relevant legislation. This involves a structured process. First, clearly explaining all legal requirements for PAL eligibility to the applicants. Second, guiding them through the application process, emphasizing the importance of accurate and complete information, particularly regarding references and declarations. Third, conducting a preliminary review of the submitted application to identify any obvious omissions or inconsistencies. And finally, advising applicants on the next steps and the role of the RCMP Canadian Firearms Program in the final decision-making process. This systematic approach ensures both the integrity of the licensing system and the applicant's informed participation. Question 9. The control framework reveals that an applicant for a possession and acquisition license, PAL, in Ontario has disclosed several past interactions with law enforcement for minor public disturbances and property damage, none of which resulted in a criminal conviction. The registrar is reviewing the application and must decide whether to proceed with the licensing process. Which of the following approaches best reflects the required due diligence and adherence to the Firearms Act, Canada? Option A. Conduct a thorough review of all disclosed incidents, obtaining relevant police reports and court records where available, to assess the applicant's past behavior and its implications for their fitness to possess firearms, while also considering any mitigating factors presented by the applicant. Option B. Rely solely on the applicant's written disclosure of past incidents and proceed with the application without seeking any external verification or additional information from law enforcement agencies. Option C. Grant the PAL application without further investigation, assuming that the absence of a criminal conviction signifies the applicant is eligible and poses no risk. Option D. Automatically deny the application upon discovering any past interactions with law enforcement, regardless of whether they led to a criminal conviction, to err on the side of caution for public safety. The correct answer is A. Conduct a thorough review of all disclosed incidents, obtaining relevant police reports and court records where available, to assess the applicant's past behavior and its implications for their fitness to possess firearms, while also considering any mitigating factors presented by the applicant. Explanation. The control framework reveals a scenario where an applicant for a possession and acquisition license, PAL, in Ontario has a history of minor infractions that, while not resulting in a criminal conviction, raise concerns about their suitability to possess firearms. This situation is professionally challenging because it requires a nuanced assessment of risk, balancing the applicant's right to apply with public safety consideration, all within the strict confines of the Firearms Act, Canada, and its associated regulations. The registrar must exercise sound judgment to determine if the applicant meets the eligibility criteria, particularly regarding the prohibition clauses. The best professional practice involves a thorough review of all provided documentation, including any court records or police reports related to the applicant's past incidents, and a careful consideration of the specific circumstances surrounding those incidents. This approach prioritizes a comprehensive understanding of the applicant's history and its relevance to their fitness to possess firearms, as mandated by the Firearms Act. The registrar must assess whether the past behavior demonstrates a propensity for violence, irresponsibility, or a disregard for the law that would make the applicant a risk to public safety. This aligns with the overarching objective of the PAL system, which is to ensure that only responsible individuals are authorized to acquire and possess firearms. An incorrect approach would be to automatically deny the application based solely on the existence of past incidents, without a detailed examination of their nature and context. This fails to adhere to the principle of individualized assessment and may unfairly penalize an applicant for minor indiscretions that do not genuinely indicate a risk. Another incorrect approach would be to grant the license without any further investigation, assuming that the absence of a criminal conviction automatically equates to eligibility. This overlooks the registrar's duty to proactively assess suitability and could compromise public safety by disregarding potentially relevant behavioral patterns. Finally, relying solely on the applicant's self-reporting without corroborating evidence or further inquiry, especially when concerning incidents are mentioned, would be a failure to exercise due diligence. Professionals should employ a decision-making framework that begins with a clear understanding of the legal requirements for PAL eligibility. This involves meticulously reviewing the applicant's application and supporting documents, identifying any potential red flags. For each red flag, the professional must then conduct a targeted investigation to gather all relevant information, including police records and court documents, if applicable. The information gathered must then be analyzed in the context of the Firearms Act's prohibition clauses and the overall goal of public safety. A decision should then be made based on a balanced assessment of the applicant's history, their current circumstances, and the potential risk they may pose. Question. The control framework reveals that an applicant for a possession and acquisition license, PAL, in Ontario has disclosed several past interactions with law enforcement for minor public disturbances and property damage, none of which resulted in a criminal conviction. The registrar is reviewing the application and must decide whether to proceed with the licensing process. Which of the following approaches best reflects the required due diligence and adherence to the Firearms Act, Canada? Options. A. Conduct a thorough review of all disclosed incidents, obtaining relevant police reports and court records where available, to assess the applicant's past behavior and its implications for their fitness to possess firearms, while also considering any mitigating factors presented by the applicant. B. Automatically deny the application upon discovering any past interactions with law enforcement, regardless of whether they led to a criminal conviction, to err on the side of caution for public safety. C. Grant the PAL application without further investigation, assuming that the absence of a criminal conviction signifies the applicant is eligible and poses no risk. D. Rely solely on the applicant's written disclosure of past incidents and proceed with the application without seeking any external verification or additional information from law enforcement agencies. Question 10. Benchmark analysis indicates a firearms dealer in Ontario is processing a transfer of 3 restricted firearms for a client who holds a valid possession and acquisition license PAL. The established transfer fee structure in Ontario dictates a $10 fee for the first firearm and $5 for each additional firearm. The harmonized sales tax, HST, in Ontario is 13%. What is the correct total fee the dealer must charge the client for this transfer? Option A, $22.60. Option B, $33.90. Option C, $30.00. Option D, $25.40. The correct answer is A, $22.60. Explanation: Scenario analysis. This scenario presents a professional challenge related to the accurate calculation of firearm transfer fees under Ontario's specific regulatory framework for the possession and acquisition license, PAL. Misinterpreting the fee structure or applying incorrect calculations can lead to non-compliance with the Firearms Act, Ontario, and its associated regulation, potentially resulting in administrative penalties or delays in license processing. The challenge lies in precisely applying the tiered fee structure based on the number of firearms being transferred, ensuring all applicable taxes are accounted for. Correct approach analysis. The best professional practice involves meticulously calculating the transfer fee by first determining the base fee for the first firearm, and then adding the incremental fees for each subsequent firearm, ensuring that the harmonized sales tax, HST, is applied to the total calculated fee. This approach directly adheres to the fee schedule outlined in Ontario's regulations for firearm transfers. For instance, if the base fee for the first firearm is $10 and each additional firearm incurs a $5 fee, and HST is 13%, then for 3 firearms, the calculation would be: base fee for first firearm equals $10. Fees for 2 additional firearms equals $5 equals $10. Total base transfer fee equals $10 plus $10 equals $20. HST equals $20*0. 13 equals $2.60. Total fee equals $20 plus $2.60 equals $22.60. This precise calculation ensures compliance with the fee structure and tax obligations as stipulated by Ontario law. Incorrect approaches analysis. One incorrect approach is to apply a flat fee for all firearms regardless of the number being transferred. This fails to acknowledge the tiered fee structure mandated by Ontario regulations, which differentiates costs based on the quantity of firearms. This would result in an underpayment of the required transfer fee, leading to non-compliance. Another incorrect approach is to calculate the HST on the fee for only the first firearm and then add the incremental fees without tax. This misapplies the tax, as HST is generally levied on the total value of the transaction, including all associated fees. This would also lead to an underpayment of the total required fee. A further incorrect approach is to simply sum the base fees for each firearm without considering the tiered structure where the first firearm has a distinct fee. For example, if the regulation states a $10 fee for the first firearm and $5 for each additional, simply multiplying the number of firearms by a single rate e.g., $7.50 per firearm would be inaccurate and non-compliant. Professional reasoning. Professionals must adopt a systematic approach to fee calculation, breaking down the process into distinct steps, identifying the base fee for the initial firearm, calculating incremental fees for subsequent firearms, summing these to determine the total base transfer fee, and finally, applying the applicable provincial sales tax, HST, in Ontario to the entire base fee. This methodical process, grounded in a thorough understanding of the specific fee schedule and tax laws of Ontario, ensures accuracy and regulatory compliance. When faced with fee structures, always refer to the official documentation provided by the relevant provincial authority. Question 11. Which approach would be considered the most professionally responsible and legally compliant for an individual applying for a possession and acquisition license, PAL, in Ontario, Canada, who has had past incidents involving domestic disputes where restraining orders were issued, but no criminal charges were ultimately laid or convictions recorded? Option A. Only disclose domestic dispute incidents where criminal charges were laid or convictions were recorded, as these are the only legally significant events. Option B. Seek legal advice solely to determine the minimum information that must be disclosed to avoid any potential legal repercussions, rather than focusing on complete transparency. Option C. Fully disclose all past domestic dispute incidents, including those with restraining orders, on the PAL application form, even if no criminal charges were laid or convictions resulted. Option D. Omit any mention of domestic dispute incidents from the application, assuming that the absence of charges or convictions means they are not relevant to the PAL application. The correct answer is C. Fully disclose all past domestic dispute incidents, including those with restraining orders, on the PAL application form, even if no criminal charges were laid or convictions resulted. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the complexities of the Canadian Firearms Act and its associated regulations when applying for possession and acquisition license PAL. The challenge lies in accurately and truthfully disclosing all relevant personal history, as omissions or misrepresentations can lead to severe consequences, including license denial, revocation, and potential legal repercussions. The applicant must understand that the application process is designed to assess their suitability to possess firearms safely and responsibly, and any attempt to conceal information undermines this fundamental objective. Correct approach analysis. The best professional practice involves a complete and truthful disclosure of all requested information on the PAL application form, including any past instances of domestic violence, regardless of whether charges were laid or convictions resulted. This approach aligns directly with the requirements of the Canadian Firearms Act, specifically Section 10 of the Firearms Act, which mandates that an applicant must provide truthful and complete answers to all questions on the application. Furthermore, the Criminal Records Act and related provincial legislation concerning domestic violence interventions and restraining orders are critical considerations. The Canadian Firearms Program, CFP, has specific policies and procedures for assessing individuals with a history of domestic violence, and full disclosure allows the CFP to conduct a thorough risk assessment. Failing to disclose such information is considered a serious misrepresentation and can lead to immediate denial or revocation of a PAL. Incorrect approaches analysis. Providing incomplete information by only disclosing instances where charges were laid or convictions occurred, while omitting any allegations or restraining orders, is professionally unacceptable. This approach fails to meet the statutory requirement for full disclosure under the Firearms Act. The CFP assesses a broad range of factors related to public safety, and restraining orders or documented incidents of domestic violence, even without formal charges, can indicate a risk to public safety. Omitting any mention of domestic violence incidents altogether, assuming that because no charges were laid or convictions resulted, it is not relevant, is also professionally unacceptable. This demonstrates a misunderstanding of the comprehensive nature of the PAL application process, which aims to identify potential risks beyond formal legal outcomes. The intent of the legislation is to prevent firearms from falling into the hands of individuals who may pose a risk, and past behavior, even if not legally prosecuted, can be indicative of such risk. Consulting with a legal professional to determine the minimum information required to avoid legal trouble, rather than focusing on full and truthful disclosure, is professionally unsound. While legal advice is important, the primary ethical and legal obligation for a PAL applicant is to be completely honest and transparent with the CFP. This approach prioritizes circumventing potential legal issues over fulfilling the spirit and letter of firearms legislation, which is designed for public safety. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes absolute honesty and adherence to regulatory requirements. When faced with an application process that requires disclosure of personal history, the professional's duty is to ensure all information provided is accurate, complete, and truthful, as mandated by the governing legislation. This involves understanding the scope of the questions asked and the underlying public safety objectives of the regulatory framework. If there is any doubt about what needs to be disclosed, it is always best practice to err on the side of overdisclosure and provide all relevant information, allowing the regulatory body to make an informed assessment. This proactive approach minimizes the risk of misrepresentation and upholds professional integrity. Question 12. Investigation of an applicant's history for a possession and acquisition license in Ontario reveals a past period of treatment for a mental health condition. What is the most appropriate course of action for the applicant to ensure a thorough and fair assessment of their eligibility? Option A. Provide vague or misleading information about the mental health history, minimizing its significance. Option B. Withhold information about the past mental health treatment, assuming it is not directly relevant to firearm possession. Option C. Refuse to provide any supporting documentation from healthcare providers, even if requested by the Chief Firearms Officer. Option D. Proactively disclose the past mental health treatment to the Chief Firearms Officer in Ontario, providing supporting documentation from their treating physician or mental health professional. Correct answer is D. Proactively disclose the past mental health treatment to the Chief Firearms Officer in Ontario, providing supporting documentation from their treating physician or mental health professional. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual applying for a possession and acquisition license, PAL, in Ontario to navigate the complexities of disclosing past mental health treatment. The challenge lies in balancing the legal requirement for disclosure with the personal sensitivity of the information, and understanding how this information is assessed under the Firearms Act, Canada, and its associated regulations. The applicant must provide accurate information without jeopardizing their application unnecessarily, while the Chief Firearms Officer, CFO, must assess the risk posed by the applicant's history. Careful judgment is required to ensure all relevant information is provided in a manner that allows for a fair and thorough assessment. Correct approach analysis. The best professional practice involves the applicant proactively and truthfully disclosing their past mental health treatment to the Chief Firearms Officer, CFO, in Ontario, along with supporting documentation from their treating physician or mental health professional. This approach is correct because Section 10 of the Firearms Act, Canada, mandates that an applicant for a PAL must provide information that the CFO considers necessary to determine if the applicant is eligible. While the Act does not explicitly require disclosure of mental health history, the CFO has the authority to request such information if they deem it relevant to assessing the applicant's fitness to possess firearms. By voluntarily providing this information and professional assessments, the applicant demonstrates transparency and allows the CFO to make an informed decision based on current mental state and prognosis, rather than solely on past events. This aligns with the ethical principle of honesty and the regulatory intent to ensure public safety. Incorrect approach is analysis. One incorrect approach is for the applicant to withhold information about their past mental health treatment, believing it is not directly relevant or hoping it will not be discovered. This is a regulatory failure because the CFO has broad powers to request information deemed necessary for eligibility assessment. Withholding information, even if not explicitly asked for in the initial application, can be interpreted as a lack of candor and may lead to the application being refused or even revoked if discovered later. Ethically, it undermines the principle of full disclosure required for a fair assessment. Another incorrect approach is for the applicant to provide vague or misleading information about their mental health history, downplaying the severity or duration of treatment. This is a significant regulatory and ethical failure. It misrepresents the applicant's history and prevents the CFO from conducting a proper risk assessment. Such misrepresentation can have serious consequences, including the denial of the PAL and potential future prohibitions. A third incorrect approach is for the applicant to refuse to provide any supporting documentation from their healthcare providers, even after being requested by the CFO. This is a direct contravention of the CFO's authority to gather necessary information. Failure to comply with such requests is a clear indicator of non-cooperation and can lead to the application being refused on the grounds of insufficient information to assess eligibility, thereby failing to meet the requirements of Section 10 of the Firearms Act. Professional reasoning. Professionals in this situation should adopt a proactive and transparent approach. The decision-making process should involve understanding the legal obligations under the Firearms Act, Canada, and the specific requirements of the Ontario CFO. When dealing with sensitive personal information like mental health history, the professional approach is to disclose truthfully and provide corroborating evidence from qualified professionals. This demonstrates good faith and facilitates a comprehensive assessment by the licensing authority. If unsure about what information is required or how to present it, seeking advice from legal counsel specializing in firearms law or directly from the CFO's office is advisable. The overarching principle is to enable the CFO to make an informed decision regarding public safety and the applicant's fitness to possess firearms. Question 13. In Ontario, an individual applying for possession and acquisition license, PAL, has a past record of being arrested for a minor offense several years ago. The individual participated in a diversion program and successfully completed it, resulting in no formal conviction. When completing the PAL application, which requires disclosure of any interactions with law enforcement, what is the most appropriate course of action for the applicant? Option A. State on the application that the arrest never occurred, believing the diversion program effectively nullified the event. Option B. Only disclose the successful completion of the diversion program, omitting any mention of the arrest. Option C. Do not disclose any information regarding the arrest or the diversion program, as there was no formal conviction. Option D. Fully disclose the arrest and the successful completion of the diversion program to the RCMP Canadian Firearms Program. The correct answer is D. Fully disclose the arrest and the successful completion of the diversion program to the RCMP Canadian Firearms Program. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to accurately and truthfully disclose all relevant information to the Royal Canadian Mounted Police RCMP, Canadian Firearms Program, CFP, during the application process for possession and acquisition license, PAL, in Ontario. Failure to do so can lead to serious consequences, including license denial, revocation, and potential criminal charges. The applicant's past behavior, even if seemingly minor or resolved, must be assessed against the criteria set out in the Firearms Act. Correct approach analysis. The best professional practice is to fully and accurately disclose the past arrest and subsequent diversion program completion to the RCMP CFP. This approach is correct because Section 5 of the Firearms Act Canada requires applicants to provide truthful and complete information. While the applicant successfully completed the diversion program, which may have prevented a formal conviction, the arrest itself is a material fact that must be disclosed. The RCMP CFP will assess the circumstances of the arrest and the completion of the diversion program to determine eligibility. Honesty and transparency are paramount in maintaining public trust and ensuring compliance with firearms legislation. Incorrect approaches analysis. Providing incomplete information by only mentioning the diversion program without disclosing the arrest is a failure to meet the statutory requirement of full disclosure. This misrepresentation can be interpreted as an attempt to conceal relevant information, leading to a finding of ineligibility or revocation of a license. Failing to disclose any information about the arrest or diversion program entirely is a direct violation of the Firearms Act's disclosure requirements. This omission is a serious misrepresentation and will likely result in the denial of the PAL application upon discovery. Providing misleading information by claiming the arrest never happened, even if the applicant believes the diversion program effectively erased the event, is a deliberate falsehood. This constitutes fraud or misrepresentation in the application process, which carries severe penalties under Canadian law. Professional reasoning. Professionals assisting applicants with PAL applications in Ontario must adopt a proactive and transparent approach. The decision-making framework should prioritize adherence to the Firearms Act and its regulations. This involves 1. Thoroughly understanding the applicant's history, including any interactions with law enforcement. 2. Educating the applicant on the absolute necessity of full and truthful disclosure, regardless of their perception of the outcome of past events. 3. Assisting the applicant in accurately documenting all relevant information, including dates, circumstances, and outcomes of any arrests or legal proceedings. 4. Advising the applicant that the RCMP CFP will conduct its own assessment based on the disclosed information and may request further details or documentation. The professional's role is to facilitate a compliant application, not to circumvent or obscure relevant facts. Question 14. Benchmark analysis indicates that a firearms safety course instructor in Ontario, Canada, is assessing an applicant for a possession and acquisition license, PAL. The applicant discloses a history of several domestic disputes with a former partner over the past 5 years, though no charges were ever laid. The applicant states these were minor disagreements that have been resolved. What is the most appropriate course of action for the instructor to take in assessing this applicant's suitability? Option A. Conduct a thorough inquiry into the domestic dispute history, seeking clarification and potentially additional documentation from the applicant, and objectively evaluate if this history indicates unsuitability or a risk to public safety, according to the Firearms Act, Canada, and the Criminal Code of Canada, refusing certification if reasonable grounds exist. Option B. Issue a provisional certification, recommending further investigation by the local police service before a final decision is made by the chief firearms officer. Option C. Certify the application immediately, as no formal charges were laid, and the applicant has stated the disputes were minor and resolved. Option D. Advise the applicant that due to the disclosure of domestic disputes, regardless of charges, they are automatically deemed unsuitable and should not proceed with the application. The correct answer is A. Conduct a thorough inquiry into the domestic dispute history, seeking clarification and potentially additional documentation from the applicant, and objectively evaluate if this history indicates unsuitability or a risk to public safety, according to the Firearms Act, Canada, and the Criminal Code of Canada, refusing certification if reasonable grounds exist. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms safety course instructor in Ontario, Canada, who is tasked with assessing an applicant's eligibility for a possession and acquisition license, PAL. The challenge lies in balancing the legal requirements for PAL issuance with the instructor's ethical obligation to ensure public safety and uphold the integrity of the firearms licensing system. The instructor must navigate the specific provisions of the Firearms Act, Canada, and the Criminal Code of Canada, as well as provincial regulations and best practices for PAL assessments, to make a sound recommendation. The applicant's history of domestic disputes, even if not resulting in formal charges, raises significant concerns regarding their suitability to possess firearms, requiring careful consideration of the public safety and suitability criteria. Correct approach analysis. The best professional practice involves a thorough and documented assessment that directly addresses the applicant's suitability based on the information provided and the instructor's professional judgment, while adhering strictly to the requirements of the Firearms Act, Canada, and the Criminal Code of Canada. This approach necessitates a detailed inquiry into the domestic dispute history, seeking clarification from the applicant, and potentially requesting additional documentation or references. The instructor must then objectively evaluate whether the applicant's past behavior demonstrates a risk to public safety or indicates unsuitability to possess firearms, as defined by the relevant legislation. If, after this comprehensive assessment, the instructor has reasonable grounds to believe the applicant is not a fit and proper person to possess a firearm, they must refuse to certify the application and clearly articulate the reasons for this refusal, citing the specific legal provisions that support their decision. This ensures transparency, accountability, and adherence to the law, prioritizing public safety. Incorrect approaches analysis. One incorrect approach involves overlooking the significance of the reported domestic disputes simply because no formal charges were laid. This failure to investigate further, despite the instructor's knowledge of the incidents, contravenes the spirit and intent of the suitability provisions in the Criminal Code of Canada and the Firearms Act, Canada. The legislation requires consideration of any information that might indicate unsuitability, and domestic disputes, even without charges, can be indicative of potential risks to public safety. Another incorrect approach is to certify the application without adequately documenting the assessment process and the rationale for the decision. A lack of thorough documentation makes it impossible to justify the instructor's recommendation if it is later reviewed by the chief firearms officer. This omission fails to meet the professional standard of due diligence and can undermine the integrity of the licensing process. A further incorrect approach would be to certify the application based solely on the applicant's assertion that the disputes were minor or resolved, without independently verifying this information or considering the potential for ongoing issues. This approach prioritizes the applicant's convenience over public safety and the instructor's responsibility to conduct a comprehensive assessment as mandated by the licensing framework. Professional reasoning. Professionals in this role must adopt a risk-based decision-making framework. This involves proactively identifying potential risks to public safety, thoroughly investigating any concerns raised, and making decisions that are grounded in legal requirements and ethical considerations. When assessing suitability for a PAL, instructors should always err on the side of caution when public safety is a factor. They must maintain detailed records of their assessments, clearly articulating the evidence considered and the legal basis for their recommendations. If doubts about an applicant's suitability persist after a thorough investigation, the professional obligation is to refuse certification and provide a clear, legally defensible explanation. Question 15. Risk assessment procedures indicate that a firearms safety course instructor in Ontario, Canada, has observed a potential applicant exhibiting concerning behavior during the course, including aggressive outbursts and a dismissive attitude towards safety protocols, though no formal charges were laid. What is the most appropriate course of action for the instructor regarding the applicant's possession and acquisition license, PAL, application? Option A. Dismiss the applicant's behavior as inconsequential since no arrest or conviction occurred, and proceed with certifying their course completion. Option B. Issue the course completion certificate but privately advise the applicant that they should not proceed with their PAL application. Option C. Document all observed behaviors and concerns thoroughly and submit this information to the Chief Firearms Officer, CFO, for Ontario for their assessment. Option D. Directly deny the applicant a PAL based on the instructor's personal assessment of their unsuitability. The correct answer is C. Document all observed behaviors and concerns thoroughly and submit this information to the Chief Firearms Officer, CFO, for Ontario for their assessment. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms safety course instructor in Ontario, Canada, who is tasked with assessing a potential applicant's suitability for a possession and acquisition license, PAL. The challenge lies in balancing the legal requirements for PAL issuance with the instructor's ethical obligation to ensure public safety and uphold the integrity of the firearms licensing system. The instructor must navigate the nuances of the applicant's past behavior, which, while not a direct criminal conviction, raises concerns about their judgment and potential risk. Careful consideration of the Firearms Act Canada and its associated regulations, particularly concerning the definition of prohibited person and the assessment of an applicant's suitability, is paramount. Correct approach analysis. The best professional practice involves diligently documenting all observed behaviors and concerns, and then forwarding this comprehensive information to the Chief Firearms Officer, CFO, for Ontario. This approach is correct because the CFO is the designated authority responsible for making the final determination on PAL eligibility. The instructor's role is to facilitate the safety course and provide an assessment based on their observations during the course. They are not empowered to unilaterally approve or deny a PAL application. By submitting all relevant information, the instructor fulfills their duty to report potential risks without overstepping their authority, allowing the CFO to conduct a thorough investigation and make an informed decision based on the totality of the circumstances, as mandated by the Firearms Act and the Criminal Records Act, Canada, concerning background checks and suitability assessments. Incorrect approach is analysis. One incorrect approach is to dismiss the applicant's behavior as irrelevant because there was no arrest or conviction. This is ethically and regulatorily flawed because the Firearms Act suitability assessment extends beyond formal convictions. Past behavior, even without a criminal record, can indicate a propensity for violence, poor judgment, or disregard for laws, which are all factors the CFO must consider. Failing to report such concerns abdicates the instructor's responsibility to public safety. Another incorrect approach is to directly deny the applicant a PAL based solely on the instructor's personal judgment of their behavior. This is incorrect because the instructor lacks the legal authority to make such a decision. The PAL application process is governed by specific legislation, and only the CFO has the mandate to approve or refuse an application after a comprehensive review. The instructor's role is advisory and observational, not adjudicatory. A third incorrect approach is to approve the applicant's course completion certificate while privately advising them against applying for a PAL. While seemingly a compromise, this is still professionally problematic. It creates a disconnect between the formal certification and the instructor's private concerns. It also fails to formally alert the authorities to potential risks, leaving the responsibility of further investigation solely on the applicant, which is not the intended process for ensuring public safety. The formal reporting mechanism to the CFO is designed to ensure that all relevant information is considered by the appropriate authority. Professional reasoning. Professionals in this role should adopt a framework that prioritizes adherence to legal mandates, ethical responsibilities, and the principle of public safety. This involves understanding the scope of their authority and responsibilities within the regulatory framework. When concerns arise, the decision-making process should focus on gathering objective information, documenting observations meticulously, and reporting these findings to the designated authority, the CFO in this case, for their expert assessment and decision. This ensures a fair process for the applicant, while upholding the integrity and safety objectives of the firearms licensing system in Ontario. Question 16. Benchmark analysis indicates that a firearms safety course instructor in Ontario, Canada, is reviewing a possession and acquisition license, PAL, application. The applicant presents a completed application form and a provincial health card. The instructor notices a slight difference in the applicant's date of birth listed on the application compared to the health card, and the applicant states they have not yet completed the mandatory firearms safety course, but will do so next month. What is the most appropriate course of action for the instructor to ensure compliance with Ontario's firearms regulations? Option A. Accept the application as is, noting the minor date of birth discrepancy and the applicant's verbal commitment to complete the firearms safety course, and proceed with processing the application. Option B. Advise the applicant to correct the date of birth on the application form and inform them that the firearms safety course completion can be submitted at a later date once the initial application is accepted. Option C. Reject the application outright due to the date of birth discrepancy and the lack of immediate proof of firearms safety course completion, without offering any guidance on how to rectify the issues. Option D. Verify the applicant's identity and residency using the provincial health card. Request official documentation to clarify the date of birth discrepancy, and inform the applicant that the PAL application cannot be processed until proof of successful completion of the mandatory firearms safety course is provided. The correct answer is D. Verify the applicant's identity and residency using the provincial health card. Request official documentation to clarify the date of birth discrepancy, and inform the applicant that the PAL application cannot be processed until proof of successful completion of the mandatory firearms safety course is provided. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms safety course instructor in Ontario, Canada, who is tasked with verifying the authenticity of a firearms license application. The challenge lies in balancing the legal requirement to ensure the applicant meets the criteria for a possession and acquisition license, PAL, with the ethical obligation to act with integrity and prevent the diversion of firearms to unauthorized individuals. Misjudging the authenticity of documentation or overlooking discrepancies could have severe consequences, including facilitating illegal firearm acquisition and jeopardizing public safety. Correct approach analysis. The best professional practice involves meticulously cross-referencing the information provided on the application form with the applicant's government-issued identification and any other supporting documents required by the Firearms Act, Canada, and its associated regulations. This includes verifying the applicant's identity, residency, age, and ensuring they have completed the mandatory firearms safety training. The instructor must be vigilant for any inconsistencies or red flags that might indicate fraudulent information or an attempt to circumvent the licensing process. This thorough verification process directly aligns with the legal mandate to ensure that only eligible individuals are granted a PAL, thereby upholding public safety and the integrity of the firearms regulatory system in Ontario. Incorrect approaches analysis. One incorrect approach involves accepting the application at face value based solely on the applicant's verbal assurance and the presence of a seemingly valid, but unverified, provincial health card. This fails to meet the due diligence required by the Firearms Act, which mandates robust verification of identity and eligibility. The instructor would be ethically compromised by not performing adequate checks, potentially enabling an unqualified individual to obtain a firearm. Another incorrect approach is to proceed with the application process without confirming the applicant's completion of the required firearms safety course, relying instead on a promise that it will be completed later. This directly contravenes the explicit requirements of the Canadian Firearms Program and the provincial regulations governing PALs in Ontario, which mandate successful completion of an approved course prior to application submission. This oversight poses a significant risk to public safety. A third incorrect approach is to dismiss a minor discrepancy in the applicant's stated address between the application and their identification as insignificant, assuming it's a simple clerical error. While minor errors can occur, the regulatory framework requires accurate and consistent information. Failing to investigate such discrepancies could mask an attempt to mislead authorities or indicate a lack of attention to detail that is critical for responsible firearm ownership. This approach neglects the importance of precise data in the licensing process. Professional reasoning. Professionals in this role must adopt a systematic and cautious approach. This involves understanding the specific documentation requirements outlined by the Royal Canadian Mounted Police (RCMP), Canadian Firearms Program, and the Ontario Ministry of the Solicitor General. When faced with any ambiguity or potential inconsistency, the professional decision-making process should prioritize seeking clarification, verifying information through official channels, and if necessary, refusing to proceed until all regulatory requirements are unequivocally met. This proactive stance ensures compliance and upholds the highest ethical standards in managing firearms licensing. Question 17. Benchmark analysis indicates that an applicant for a possession and acquisition license, PAL in Ontario, Canada, has had a past interaction with law enforcement concerning a domestic dispute that resulted in police attendance but no charges being laid. The applicant is unsure whether to disclose this incident on their PAL application. Which of the following approaches best reflects best practice and regulatory compliance for this applicant? Option A. Assume that because no charges were laid, the incident is minor and does not require disclosure. Option B. Fully and truthfully disclose the incident to the Canadian Firearms Program, including the details of the police attendance and the nature of the dispute, regardless of the absence of charges. Option C. Disclose only the information that the applicant believes will present them in the most favorable light. Option D. Only disclose incidents where formal charges were laid by law enforcement. The correct answer is B. Fully and truthfully disclose the incident to the Canadian Firearms Program, including the details of the police attendance and the nature of the dispute, regardless of the absence of charges. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to accurately and completely disclose all relevant information to the Canadian Firearms Program, CFP, during the application process for a possession and acquisition license PAL. Failure to do so, even if unintentional, can lead to serious consequences, including license refusal, revocation, and potential legal repercussions. The applicant's past interactions with law enforcement, even if resolved without charges, are considered material to assessing their suitability to possess firearms. The challenge lies in understanding the scope of what needs to be disclosed and the potential impact of omissions. Correct approach analysis. The best professional practice involves a proactive and transparent approach to disclosure. This means the applicant should fully and truthfully disclose all past interactions with law enforcement, including the incident involving a domestic dispute that led to police attendance, regardless of whether charges were laid or the outcome of the interaction. This approach aligns with the requirements of the Firearms Act Canada and its associated regulation, which mandate that applicants provide all information necessary to determine their eligibility. Specifically, the applicant must disclose any history that might be relevant to public safety or their suitability to possess firearms. By disclosing this incident, the applicant demonstrates honesty and allows the CFP to conduct a thorough assessment based on complete information, thereby adhering to the spirit and letter of the law. Incorrect approaches analysis. One incorrect approach involves only disclosing incidents where charges were laid. This is a failure to comply with the disclosure requirements of the Firearms Act. The CFP is interested in any interaction with law enforcement that might indicate a risk, not solely those resulting in formal charges. Failing to disclose the domestic dispute, even if no charges were filed, omits relevant information that could influence the CFP's decision. Another incorrect approach is to assume that because the incident was minor or resolved without legal proceedings, it does not need to be disclosed. This is a misinterpretation of the disclosure obligations. The onus is on the applicant to provide all information that the CFP deems relevant for their assessment of suitability. The absence of charges does not automatically render an incident irrelevant. A third incorrect approach is to only disclose information that the applicant believes is favorable. This demonstrates a lack of candor and an attempt to manipulate the application process. The Firearms Act requires a complete and truthful disclosure of all relevant information, not a curated selection of facts. This approach undermines the integrity of the application and the regulatory process. Professional reasoning. Professionals involved in assisting applicants with PAL applications must guide them towards complete transparency. The decision-making framework should prioritize adherence to the Firearms Act Canada and its regulations. This involves educating applicants on the broad scope of disclosure requirements, emphasizing that any interaction with law enforcement, regardless of outcome, should be disclosed. The professional should encourage a proactive approach, advising applicants to err on the side of caution and disclose any potentially relevant information. The goal is to ensure the applicant's submission is accurate and complete, facilitating a fair and thorough assessment by the CFP and upholding the principles of public safety. Question 18. The risk matrix shows that an applicant for a possession and acquisition license, PAL, in Ontario has a history of seeking counseling for anxiety and depression approximately 5 years ago, which they believe was fully resolved and not indicative of any current risk. When completing the PAL application, how should this applicant best approach the disclosure of this mental health history? Option A. Disclose mental health history only if specifically asked for details about the diagnosis or treatment plan, rather than the fact of the treatment itself. Option B. Fail to disclose any mental health treatment or counseling, assuming that if it was minor or resolved, it does not need to be reported. Option C. Truthfully and completely disclose the history of seeking counseling for anxiety and depression, regardless of the perceived severity or recency, as required by the application's disclosure obligations. Option D. Provide incomplete information by only disclosing recent mental health treatment, omitting past instances that the applicant believes are no longer relevant. The correct answer is C. Truthfully and completely disclose the history of seeking counseling for anxiety and depression, regardless of the perceived severity or recency, as required by the application's disclosure obligations. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to accurately and comprehensively disclose all relevant information to the Royal Canadian Mounted Police (RCMP) Canadian Firearms Program (CFP) during the PAL application process. Failure to do so, even if unintentional, can lead to the denial of the application or, if discovered later, the revocation of a license. The applicant must understand the scope of what constitutes relevant information concerning their history, particularly concerning mental health, and any interactions with law enforcement or mental health professionals that might be pertinent to public safety. The onus is on the applicant to be truthful and complete. Correct approach analysis. The best professional practice involves the applicant proactively and truthfully disclosing any history of mental health treatment or counseling, regardless of how long ago it occurred or whether they currently perceive themselves as a risk. This approach aligns with the fundamental principle of the Firearms Act, Canada, and its associated regulations, which prioritize public safety. The application form specifically asks questions designed to elicit information that could impact an individual's suitability to possess firearms. Full disclosure allows the CFP to conduct a thorough risk assessment, which may involve consulting medical records or other sources as permitted by law. This transparency ensures that the CFP has all necessary information to make an informed decision, upholding the spirit and letter of the law. Incorrect approach is analysis. Providing incomplete information by only disclosing recent mental health treatment, while omitting past instances, is a significant regulatory failure. The CFP is concerned with an applicant's overall history and pattern of behavior, not just their most recent experiences. Omitting past treatment suggests a lack of understanding of the application's requirements or an attempt to conceal potentially relevant information, which undermines the integrity of the application process. Failing to disclose any mental health treatment or counseling, even if the applicant believes it was minor or resolved, constitutes a direct contravention of the application's disclosure requirements. This omission is a serious ethical and regulatory breach, as it deprives the CFP of critical information necessary for a comprehensive risk assessment. It implies a disregard for the legal obligations associated with firearm ownership and poses a potential risk to public safety. Disclosing mental health history only if specifically asked for details about the diagnosis or treatment plan, rather than the fact of the treatment itself, is also an insufficient approach. The application questions are designed to be broad enough to capture any relevant history. The applicant's obligation is to disclose the existence of treatment, allowing the CFP to then request further details if deemed necessary for their assessment. This selective disclosure risks misinterpreting the intent of the application questions and failing to meet the disclosure requirements. Professional reasoning. Professionals in this situation must adopt a mindset of full transparency and proactive disclosure, and completing any application that requires disclosure of personal history, especially concerning public safety. The guiding principle should be to err on the side of providing more information rather than less. Applicants should carefully read and understand each question, considering the potential implications of their answers from the perspective of the regulatory body. If there is any doubt about whether a piece of information is relevant, it is best to disclose it. This approach not only ensures compliance with legal requirements, but also demonstrates a commitment to responsible firearm ownership and public safety. Question 19. Process analysis reveals that an individual in Ontario, Canada, is applying for a possession and acquisition license (PAL) and intends to possess a firearm that they believe is not prohibited under provincial law. They have also made modifications to the firearm, which they feel makes it compliant. What is the most appropriate course of action for the applicant and the licensing authority to ensure compliance with Canadian federal firearms legislation? Option A. Inform the applicant that a firearm classified as prohibited under the Federal Firearms Act, Canada, will prevent them from obtaining a standard PAL and advise them to consult official Canadian Firearms Program resources or a legal professional for guidance on their specific situation. Option B. Recommend that the applicant store the firearm securely and await further instructions from the licensing authority without clarifying its legal status in relation to the PAL application. Option C. Suggest that the applicant focus on the PAL application and disregard the firearms classification for now, as provincial regulations are the primary concern for licensing in Ontario. Option D. Advise the applicant that, since the firearm is not prohibited in Ontario and has been modified, they can proceed with the PAL application and address the firearm status after the license is issued. Correct answer is A. Inform the applicant that a firearm classified as prohibited under the Federal Firearms Act, Canada, will prevent them from obtaining a standard PAL and advise them to consult official Canadian Firearms Program resources or a legal professional for guidance on their specific situation. Explanation. Scenario analysis. This scenario presents a professional challenge related to the application process for a possession and acquisition license, PAL, in Ontario, Canada. The challenge lies in accurately interpreting and applying the requirements of the Firearms Act, Canada, and its associated regulations, specifically concerning the definition of prohibited firearm and the implications for a PAL application. Misinterpreting these regulations can lead to incorrect advice, potentially causing significant delays, financial loss, or even legal repercussions for the applicant. Careful judgment is required to ensure all legal criteria are met and the applicant is guided appropriately through the process. Correct approach analysis. The best professional practice involves a thorough understanding of the Firearms Act, Canada, and its regulations, particularly those defining prohibited firearms. This approach correctly identifies that a firearm classified as prohibited under Canadian law, regardless of its intended use or modification status, will prevent an individual from obtaining a standard PAL. The applicant must be informed that their current firearm classification renders them ineligible for a standard PAL, and that they should consult the official Canadian Firearms Program resources or a qualified legal professional specializing in firearms law for guidance on potential alternative licensing or firearm ownership options. if any exist, that might accommodate their situation under specific limited circumstances, e.g., specific museum licenses, etc., though these are rare and highly regulated. This is correct because the PAL application process is strictly governed by federal legislation, and eligibility hinges on compliance with these laws, including prohibitions on certain firearm types. Incorrect approach is analysis. One incorrect approach involves advising the applicant that the firearm can be legally possessed with a standard PAL simply because it is not currently prohibited in their province of residence or because it has been modified. This is incorrect because provincial laws do not supersede federal firearms classifications. The Firearms Act Canada defines prohibited firearms federally, and possession of such firearms generally requires specific, restricted authorizations that are not part of a standard PAL. Modifying a firearm does not change its inherent classification under the Act if it was originally prohibited. Another incorrect approach is to suggest that the applicant can proceed with the PAL application and address the firearm issue later. This is professionally unsound and potentially illegal. The PAL application requires disclosure of all relevant information, and failing to declare or misrepresenting the nature of firearms intended for possession can lead to application refusal, revocation of any issued license, and potential criminal charges. The eligibility criteria must be met at the time of application. A further incorrect approach is to recommend that the applicant simply store the firearm indefinitely without clarifying its legal status and its impact on the PAL application. While safe storage is a general requirement, this approach fails to address the fundamental issue. The firearms classification likely makes the applicant ineligible for a standard PAL. This passive approach does not provide the applicant with the necessary information to make informed decisions about their firearm ownership and licensing goals. Professional reasoning. Professionals dealing with PAL applications must adopt a proactive and legally informed stance. The decision-making process should begin with a comprehensive review of the applicant's stated intentions and firearm inventory against the current federal legislation and regulations governing firearms in Canada. When a potential conflict arises, such as the possession of a firearm that may be prohibited, the professional's duty is to clearly and accurately inform the applicant of the legal implications. This includes explaining the specific provisions of the Firearms Act Canada that are relevant. If the applicant's situation appears to render them ineligible for the requested license, the professional should advise them to seek clarification from official sources, such as the Royal Canadian Mounted Police, RCMP, Canadian Firearms Program, or consult with a legal expert specializing in firearms law. The priority is always to ensure the applicant understands their legal obligations and the requirements for obtaining and maintaining a firearms license. Question 20. The efficiency study reveals that a licensed individual in Ontario possesses 3 detachable magazines, each with a stated capacity of 10 rounds, for a semi-automatic centerfire rifle. What is the maximum number of rounds of ammunition this individual can legally possess for these magazines, adhering to the Firearms Act Canada and Ontario's regulations? Option A, 30 rounds. Option B, 15 rounds. Option C, 25 rounds. Option D, 10 rounds. The correct answer is B, 15 rounds. Explanation. Scenario analysis. This scenario presents a professional challenge by requiring the accurate calculation of the maximum allowable ammunition capacity for a specific firearm based on its magazine capacity and the applicable provincial regulations in Ontario. Misinterpreting or miscalculating this can lead to violations of the Firearms Act Canada and Ontario's specific regulations concerning firearm and ammunition possession, potentially resulting in legal penalties and the revocation of a possession and acquisition license, PAL. Careful judgment is required to ensure compliance with the law. Correct approach analysis. The best professional practice involves accurately calculating the maximum allowable ammunition based on the firearm's stated magazine capacity and the legal limits defined by the Firearms Act, Canada, and Ontario regulations. This approach correctly identifies that for a semi-automatic centerfire rifle with a detachable magazine, the maximum capacity is generally limited to 5 rounds. Therefore, multiplying the magazine's stated capacity, 10 rounds, by the number of magazines 3, and then applying the legal limit of 5 rounds per magazine for this class of firearm is the correct method. The calculation is 3 magazines asterisk 5 round slash magazine equals 15 rounds. This adheres strictly to the legal framework governing ammunition possession for such firearms in Ontario. Incorrect approaches analysis. One incorrect approach involves simply multiplying the stated magazine capacity by the number of magazines without considering the legal restrictions on ammunition capacity per magazine for certain firearm types. This fails to acknowledge the specific limitations imposed by the Firearms Act, Canada, for semi-automatic centerfire rifles with detachable magazines, which restricts the number of rounds that can be legally possessed in a magazine to 5. This approach would lead to an overestimation of the legally permissible ammunition. Another incorrect approach is to assume that the total number of rounds is simply the sum of the stated capacity of all magazines, ignoring any legal limits on individual magazine capacity. This directly contravenes the regulations by not accounting for the maximum number of rounds allowed in a single magazine for the specified firearm class. A further incorrect approach might be to only consider the total number of rounds that could physically fit into all magazines combined, without any regard for the legal capacity of each magazine or the type of firearm. This approach is fundamentally flawed as it disregards the legal framework entirely and focuses solely on physical capacity, leading to a significant overstatement of legally permissible ammunition. Professional reasoning. Professionals must adopt a systematic approach to ammunition calculation. This involves 1. Identifying the specific firearm type and its classification under the Firearms Act, Canada. 2. Determining the stated magazine capacity of the firearm. 3. Consulting the relevant provincial regulations, in this case, Ontario and federal laws for any specific restrictions on ammunition capacity for that firearm class. 4. Applying the most restrictive legal limit to the calculation. In this instance, the legal limit of 5 rounds per magazine for a semi-automatic centerfire rifle with a detachable magazine is paramount, overriding the physical capacity of the magazine.